Comparison of ADR versus adversarial system. 1. Nature and approach. Adversarial system. The adversarial system is a legal approach where two opposing parties present their cases before an impartial judge or jury. Example: a criminal trial in which the prosecution and defense present evidence and arguments to convince the jury of guilt or innocence. ADR. ADR encompasses various methods, including mediation, arbitration, negotiation, and conciliation, aimed at resolving disputes outside of traditional courtroom litigation. Example: two companies engaged in a contract dispute opting for arbitration to resolve the issue without going to court. 1. Nature and approach. Adversarial system. The adversarial system is a legal approach where two opposing parties present their cases before an impartial judge or jury. Example: a criminal trial in which the prosecution and defense present evidence and arguments to convince the jury of guilt or innocence. ADR. ADR encompasses various methods, including mediation, arbitration, negotiation, and conciliation, aimed at resolving disputes outside of traditional courtroom litigation. Example: two companies engaged in a contract dispute opting for arbitration to resolve the issue without going to court. 2. Role of parties. Adversarial system. Parties play an active role in presenting evidence, examining witnesses, and arguing their case. Example: in a civil lawsuit, both the plaintiff and the defendant actively participate in the trial process. ADR. Parties have a more active role in the resolution process, working together with a neutral third party to find a mutually agreeable solution. Example: mediation involving divorcing spouses negotiating the terms of their separation with the assistance of a mediator. 4. Speed and cost. Adversarial system. Litigation can be time-consuming and expensive due to formalities, court procedures, and legal representation. Example: lengthy court proceedings in a complex corporate legal dispute. ADR. Generally quicker and more cost-effective than traditional litigation. Example: resolving a workplace dispute through mediation, saving time and legal expenses. 5. Preservation of relationships. Adversarial system. The adversarial nature can strain relationships as the focus is on winning the case. Example: a contentious divorce proceeding leading to increased animosity between the spouses. ADR. ADR methods emphasize collaboration and often preserve relationships. Example: mediation in a family inheritance dispute, allowing family members to maintain a more amicable relationship. 6. Confidentiality. Adversarial system. Court proceedings are generally public, and information becomes part of the public record. Example: media coverage of a high-profile trial exposing sensitive details. ADR. ADR processes, especially mediation, often provide a more confidential setting. Example: a confidential arbitration proceeding involving a trade secret dispute between two companies. 7. Expertise of decision-makers. Adversarial system. Judges and juries are legal professionals trained to apply the law. Example: a judge with legal expertise presiding over a complex intellectual property lawsuit. ADR. Decision-makers in ADR may have specific expertise in the subject matter. Example: choosing a technical expert as an arbitrator in a construction dispute to ensure a well-informed decision. 8. Accessibility. Adversarial system. Can be less accessible for individuals without legal backgrounds. Example: a person representing themselves, pro se, in court facing challenges due to lack of legal knowledge. ADR. ADR processes, particularly mediation, are designed to be more accessible. Example: small businesses using mediation to resolve contractual disputes without the need for extensive legal representation. 9. Appeals. Adversarial system. Decisions made in court can often be appealed, leading to a potentially lengthy and complex appellate process. Example: a party dissatisfied with the trial court's decision filing an appeal to a higher court. ADR. While some forms of ADR allow for limited appeals, the overall process is typically designed to be final and binding, providing a quicker resolution. Example, in binding arbitration, parties may have limited grounds for appealing the arbitrator's decision, ensuring a more expedited resolution. 10. Control over the process. Adversarial system. Parties have less control over the litigation process. The court dictates the schedule and procedures. Example, adherence to strict court schedules and procedures in a civil lawsuit. ADR. Parties have more control over the ADR process, including the choice of the neutral third party, timing, and location. Example, parties choosing a mutually agreeable date and mediator for a commercial dispute resolution through mediation. 11. Legal representation. Adversarial system. Legal representation is often a fundamental aspect, with each party typically represented by an attorney. Example, defendants and plaintiffs in a criminal trial each having legal representation. ADR. While parties in ADR can have legal representation, it is not always required, and individuals may choose to represent themselves. Example, employees and employers participating in a workplace mediation without legal counsel. 12. Enforceability of decisions. Adversarial system. Court judgments are generally enforceable through legal mechanisms. Example, a court order enforcing the payment of damages in a breach of contract case. ADR. Enforceability in ADR depends on the specific method. Arbitration awards are often enforceable, while mediated agreements may vary. Example, enforcement of a binding arbitration award to compel a party to fulfill contractual obligations. 13. Public perception. Adversarial system. Courtroom trials are often viewed as transparent and formal, contributing to public trust in the legal system. Example, high-profile trials garnering public attention and scrutiny. ADR. Public perception of ADR methods may vary. Some see it as a pragmatic and efficient way to resolve disputes, while others may be concerned about the lack of a public forum. Example, public skepticism about the fairness of a private arbitration process involving a major corporate dispute. 14. Learning and empowerment. Adversarial system. Parties may feel less engaged in the process, with attorneys often taking the lead in legal proceedings. Example, limited direct involvement of parties in complex legal arguments presented by attorneys. ADR. ADR processes, especially mediation, can empower parties by involving them directly in the resolution process. Example, individuals actively participating in crafting solutions to their disputes during a family mediation session.